All right, so I have a couple topics to talk about. I'm just going to roll through them when I have a little bit of time between meetings. So the first thing I wanted to kind of put a bow on my conversation last night about the red herring thing, right? Because I did want to assert again that we ended that litigation pretty easily right after that, but it wasn't only because of that. I think a part of what makes that strategy successful is that you have to have merits. You have to have legal arguments on top of, something that could then be more of a ploy, shall we say, or a distraction, a way to just get the opposing party off sorts in a way. I'm not really sure how to explain that. But I want to really stress, I guess, for the title of this conversation is when they know that there's a fight. What I've seen happen a lot is that once an opposing party or a potential opposing party knows that, my client has an attorney and knows that, I don't like saying this way because, I think this way, but I try not to speak it in this way because I do, my father's a veteran and I think it's very, using war, terminology is very sensitive, but when we talk about litigation, it's very, combative in that way. It is, I forgot the word that I'm looking for, but it is combative. So I do think about it as war, you know what I mean, that you are going to war. And a lot of times I say that, I come to the opposing side with roses, but I know in my pockets I have rifles, and I have bazookas. And I think that way in terms of, going nuclear and being prepared to, go to battle. And what I found is that when you come with that posture, and usually it's a dual approach. I often, when I'm writing a letter or I'm speaking to an opposing party, I'm always sweetness and light. I always try to give them the carrot first, but I let them know very clearly and very, implicitly that I have the stick and I'm ready to do X, Y, Z. And sometimes that doesn't scare anyone, especially if they have lawyers too, because now it's just two people that are getting paid to argue, and we can just do that ad nauseum. You know what I mean? I'm just talking about the ins and outs of what's really happening. Sometimes when you have representation, for me, sometimes when I do my fees with clients, I actually stagger it that it wouldn't necessarily benefit me to continue this litigation on because I think that in and of itself is a little bit of a conflict. So I try to just have either one fee for the entire thing or to say that, I'm only going to be compensated for this one thing. I'm only going to focus on this one part. I'm not even going to contract for, anything that could happen after that. So, and I think that helps me stay only focused for the one thing that I'm doing, but also limits any issues about like conflict of interest, about trying to drag on a litigation just to get more compensation. Because I do see that sometimes from other sides, just wanting to kind of wade in the water and file motion after motion or get discovery after discovery, have meeting after meeting just to kind of up their billables. So I say that to say that, you have to really pick your battles in that sense. But I think when certain people, even before maybe they hire an attorney, when they know that your client, when my client has representation and that I'm ready to, go to war in that sense, I've seen more often than not that there's more, especially then again, if you come with, an idea for collaboration, an idea for a resolution before it gets to that point, most people will be at least considering that because they don't want to have to pay for legal fees. They just don't want to go through the rigmarole and the drama of going through an actual litigation. So I do think it's important that on top of, strategy and legalese, etc., just the idea of getting in a fight. And I want to leave you with this because this is kind of how I think about it. If you remember, in my experience, when there are bullies, and I used to be a bully, honestly, so I know, and that's not a good thing. I'm not trying to brag or anything like that. That's not good. It's not good at all. But when it comes to a bully, the last thing that a bully really wants is a fight, regardless of whether or not the bully wins or not. The bully just doesn't want to be challenged. But like, if there's someone that the bully can pick on, the bully's gonna pick on that person over and over and over and over. I was watching something on YouTube where it was talking about Michael Jordan, how he used to just like pick on some of his teammates, and if I think Horace Grant was saying like if he could ride you, he'll ride you to the moon. You know what I mean? He'll just get on you over and over and tell you everything bad. But if you fight back, he'll kind of leave you alone. And I think that's what happens with bullies, and that also what happens in litigation. If you're a punching bag in a litigation, or if you're just kind of rolling over and you start acquiescing, or especially if there's a negotiation on the table and you start really just giving the other side whatever because you're trying to get out of there, they're going to see that and they're just going to squeeze you for everything that they possibly can because they know that you just want to be done with the negotiation. But if they know that there's a fight, they might be less willing to, drag things out because they know that your endurance is just as strong, if not stronger than theirs. So I think that's really important to consider. whether or not you want to get into a fight, and knowing by getting into a fight just the leverage that you have by fighting in and of itself.